Hello and welcome to the channel. I'm Professor G, and in our last lesson we discussed how many jurists in the antebellum South believed that there was no requirement for positive law for slavery to exist. In a nutshell, to summarize that lesson, what they were saying was slavery was the natural state of people of African descent. Therefore, a state, a country, a state within the United States, any political entity did not require a positive law, meaning a law that said you can have slaves in order for slavery to be a thing. And this was in direct response to the Somerset decision, which was a case in England that happened before the establishment of the United States, where Lord Mansfield said that slavery is so odious, it goes so against human nature, it is so against the natural condition of the freedom of man, that it could only exist if there was a positive law. And since there was no law within England that says you can have slaves, that if a slave simply set foot on English soil, he was deemed free. That's how much he believed, Lord Mansfield believed, that there had to be a law that allowed slavery. So the antebellum South, the slave-holding states, needed to figure out a way to justify the existence of slavery without positive law. And that was what the last lesson that I posted on this channel covered. So go back and watch that if you haven't. Now, it's interesting because here's where they take this idea of positive law and they flip it for their benefit. So today we're again going to delve into the book, An Inquiry into the Law of Negro Slavery in the United States by Thomas R. Cobb. And again, just to reiterate from the last lesson, Thomas R. Cobb was one of the most preeminent jurists in the antebellum South. He was an attorney from Georgia. He was known as the James Madison of the Confederacy because he was instrumental in writing the Confederate Constitution. So this book isn't just some book from the antebellum South. It was used by attorneys and judges, and state Supreme Courts even cited this book in their opinions to come to their conclusions. So this isn't just some book. This is what you would have used if you were an attorney dealing with an issue with slaves in the court system in the antebellum South. So this is not only a primary source, it is one of the best primary sources to go to see how jurists in the antebellum South believed or what they thought about the laws concerning slavery. So Thomas Cobb took a lot of time to explain that no positive law is required for slavery because it is the natural state of someone of African descent. It betters their condition. Caucasians are a superior race, and therefore the Caucasians enslaving Africans, and that enslavement making them better, cultivating them, domesticating them, all of the nomenclature and wordage that he uses, in this racist ideology. He says that it is natural and it is a right and just thing. But now they actually flip the script. Because now what Cobb is going to say, and other jurists in the South, is, while no positive law is required for slavery to exist, positive law is required to limit the authority of the masters over the slaves. Now listen to how terrifying that actually is, if you understand what I'm saying. So there doesn't have to be a law that says you can have slavery, right? That's what Thomas Cobb and other Southern slaveholding jurists believe. But they also believe that if there is no law that says, for example, you cannot cut off a slave's arm, you can't mutilate a slave, if that isn't expressly listed or written in legislation, if that is not explicitly written as a code, as a law in that state, then there is nothing preventing the master from doing such a thing, right? So positive law, according to these slaveholding jurists, was required to limit the authority of a slave. So let's see what he has to say. In chapter 4 of this book, it's titled Of the Slave as a Person, Personal Security. He writes, Thomas Cobb writes, the condition of these slaves in their native country, having been one of absolute slavery, including the power over life, such would be their condition in the country to which they were removed, except so far as the same may be modified by the existing laws of their new domicile, and such subsequent legislative enactments as may have been made for their benefit. So what he's saying is that he believed that in Africa, these slaves that were brought over were in a state of absolute slavery, meaning that the master of them in Africa could go as far as taking their life. So since they were already in a state of absolute slavery, when they came to the colonies and to the United States, they remained in that state of absolute slavery unless state-specific laws limited the power or authority of the master. Now, forgetting entirely that Thomas Cobb really has no idea of what the state of these people were in enslavement in Africa. This is just what they claim. They say they were absolute slaves in Africa, therefore when they come here, they're absolute slaves here. And he does that a lot, right? Just making these assumptions of what is going on the African continent. But you understand his crazy point here is that that state of absolute slavery transferred over to whoever now owned them within the starting with the colonies and then the early United States, and eventually, of course, through the early Republic into the antebellum South, unless state-specific laws tempered the master's authority. Now he takes it, he tweaks this a little bit, because if you remember, he talks about the laws of nature. Go watch my last video, and he said you don't violate the law of nature in a system like slavery if you better the enslaved people. So if Caucasians are a superior race and the enslavement of people of African descent makes them better, then even though it might seem harsh, it's not a violation of the law of nature because the law of nature says that you can better another group of people. That's his argument in a nutshell, one of his arguments, right? Well, if the law of nature allows you to make people better, then killing them clearly doesn't make them better, right? So he addresses this. You're going to see the mental gymnastics these jurists have to go through to be able to justify the legal system that surrounds slavery, okay? So he goes on to write, the law, by recognizing the existence of a slave as a person, and I'm going to make another lesson in the future about how the states battled with this identity crisis of is a slave a person or property, and how do you reconcile the fact that states believe they were both at the same time, right? But he goes on to say, the law, by recognizing the existence of the slave as a person, thereby confers no rights or privileges except such as are necessary to protect that existence. All other rights must be granted specially. So what he's saying is, because we acknowledge the slave as a person, the only right they're given, that there doesn't have to be express legislation for, is their existence. So therefore, killing a slave, right, just because you want to kill them, would be a violation of an unwritten law, a common law, for lack of a better term, that their existence is protected, but only their existence as a person. So this might sound like a good thing, but watch how they twist this. Hence, the penalties for rape, okay, would not and should not, by such implication, be made to extend to cardinal forcible knowledge of a slave, the offense not affecting the existence of the slave, and that existence being the extent of the right which the implication of the law grants. You see how terrifying that is? If you didn't understand what he said, he says this. He says, a slave, the only rights guaranteed to a slave, unless a state actually lists out, masters can do this, masters can't do this, can't do that. The only right granted to a slave is their existence. So if a master or if anyone rapes a slave, since rape has no bearing on their existence as a person, then rape is not a crime when committed against a slave. All right? So unless the legislature actually makes a law that says there is no carnal forcible knowledge of a slave, unless that is actually on the books, then what Thomas Cobb says is there's no such thing. A slave has no protection from rape because rape doesn't affect their existence as a person, right? Only murder does, mutilation does, those sort of things. However, rape, since that wouldn't affect the existence of that slave, cannot simply be a crime unless it's expressly written in legislature. So that's absolutely terrifying. And now some of you might be saying, well, if Cobb believed that the existence of a slave was protected, how did they justify slave beatings that ended up in the death of slaves? Well, we'll cover that later on because they tap dance around that as well. And the name of the game, according to jurisprudence around antebellum slave laws and slave codes, is the absolute submission of the enslaved. So we'll cover that later, and that's another very difficult lesson to go through. But I just wanted to show you this, that Cobb says the only natural right granted to a slave is their existence. Everything else, the master has absolute authority over unless the state legislatures come in and temper that right or take that right away from the master. And the example of rape is terrifying because he actually brings it up again. And I wanted to end on this so you can see, because remember, the point of studying this is to understand that the antebellum South was not a society with slaves. It was a slave society. It was a society based entirely on a racial hierarchy, that even though something like 2% white Southerners in the antebellum South owned over 100 or so some odd slaves, right? Or a vast majority of slaves. Even though a small percentage actually owned slaves, the entire population was wound up and entangled in this system of slavery, this slave society. Again, not a society with slaves, but a slave society. And all whites in the antebellum South benefited from this racial hierarchy. And again, even the statistics about how many whites own slaves is really skewed, because you remember, if there was one head of household, if there was one rich planter who owned, let's say, 200 slaves, well, that's one person. But that doesn't include his entire family that was living on the plantation with a vested interest in this society, in this system, that was reaping the benefits of it. That even the poorest whites benefited from the racial hierarchy that existed within the system of slavery. And we'll talk about that too, that Thomas Cobb at one point talks about the authority of non-slave owners over slaves, over the enslaved. And he makes the point that all whites have to have authority over slaves to some extent to continue the system of submission, or else the system falls apart. So everyone in the antebellum South was deeply tied up in this system. And that's why it's important to study this, because at the end of the Civil War and with the failure of Reconstruction, unlike denazification in Europe that really, for the most part, and again, of course, it's 2025 as I make this video, you do see the resurgence of the radical right in Europe, but for the most part, denazification worked, whereas Reconstruction, an attempt to reform the South from the racist past and the system of slavery and the racial hierarchy, really failed. And again, we could talk about that later as well. But it's important to study this, because this is what leads to Jim Crow laws. This is what leads to the racial animosity that exists to this day, and the distrust that minorities have in the legal system, because it was, for the most part, run by people like Thomas Cobb and created by them in the early Republic and antebellum period. And these laws, the racism that created this system didn't end with the 13th Amendment. So it's important. But to give you an example of this racial hierarchy, he goes on and talks about rape again. And he brings up whether or not the state should pass laws that make the rape of a slave illegal. And he said, it is a matter worthy of consideration of the legislatures whether the offense of rape committed upon a female slave should not be indictable, and whether when committed by the master, there should not be the sale of the slave to some other master. So he's saying, I think the state, it's a matter of debate whether or not the state government should make the rape of a slave by a master illegal. And he ends it there. You see, period right there. But then he goes on to say, however, the occurrence of such an offense is almost unheard of, and the known lasciviousness of the Negro renders the possibility of its occurrence very remote. Do you understand what that means? He said, yeah, there's debate over whether or not the state legislature should make the rape of a slave by their master a crime. However, we know that the people of African descent are so lustful and so driven by their sexual desires that there can be no such thing as the rape of a slave by a master, because that slave, through their lust, wanted it. That's what he's saying. In a nutshell, that's exactly what he's saying, however horrible that is to hear. It couldn't be rape because you can't rape the willing, I guess is what he's saying. And it's actually the slave's fault because it's in their nature to be lustful and driven by their sexual desires. So in his opinion, if you were to resurrect him and bring him back, or go talk to him when he wrote this book, he would have said, I believe his opinion would have been, it shouldn't be a crime because it's the slave's fault. So it's important to study this and understand the foundations of this racial hierarchy in the system. So I know this is a hard lesson, but thank you for watching. Please remember to like, subscribe, share the video if you can, and I'll see you for the next lesson.